Overwhelming evidence identified alleged perpetrator. State of Ohio v. James Tate II. Case number 2013-0910. 8th District Court of Appeals, Cuyahoga County. The Ohio Supreme Court unanimously reversed an appeals court decision that there was insufficient evidence proving a man's identity in a kidnapping at a Cuyahoga County library.
And there is no law in dispute. The law that is proposed by the state is agreed to here by the defense. We agree that that's the law. It's a law that's been...
Was the defendant identified in court, and did he admit that he was the individual who perpetrated this offense or not?
He was not identified in court, Your Honor.
Did he admit that he was the individual in the video?
He admitted that he propositioned a young lady. He did not admit that he propositioned necessarily this young lady.
Did the police officer identify him as the individual outside the library that evening?
Yes, there is. Yes, there is two officers that testified in this case, and Neef, I believe, did testify that he saw my client speaking with a young lady out front, and I believe speaking with Brianna out front.
It's more complicated than that. He gave his business card to the young lady. Right. She gave it to the police officer. Euclid Police called him, and he picked up the phone in the library in front of the police officer. Are you suggesting, as a matter of law, that's not an ID?
Well, identity was not an issue in the case, was it?
No, it was not. It was
but
not.
It's an element of the crime. I mean, this is,
Correct.
I think that's the part of that was of concern to the Court of Appeals. You didn't have an official question of a witness asking, is this the person we're referring to? And just as venue and all the elements of the crime must be proven by the state, so must identity.
Our opinion states when you have such things as the defendant admitting that he is the person in the video that shows, discussing having sex and admits to that, that's a self-proclaimed identification. And there are various other circumstantial and I would argue somewhat direct indicia of your identification of your client in court. There is a real reason to address that, and it's because of the way this court, the 8th District wrote the opinion. And again, Mr. Price highlighted that. If this is used for authority, even in the state of Ohio, the fact that the facts are not contained and this law applied to these type of facts, it can be used for authority for something it really doesn't have the underpinnings to be authority for.
The September 4th, 2014 decision sends James Tate II's appeal back to the 8th District Court of Appeals.